Karen stood before me, holding the plat in one hand and my email in the other, then ordered the project to be shut down immediately. The trench crew froze beside my property, their shovels still dirty, while the deputy asked the foreman to step away from the flags and start naming names. Karen had come expecting a victory lap, but instead, she watched her own paperwork become the thing that buried her. 3 days earlier, she had been smiling on my gravel driveway, as if she already owned the view. At that point, I already knew what kind of woman she was. Not the loud type, but the polished kind, the kind who wrapped theft in committee language and called it neighborhood harmony. I bought that corner parcel because it was clean, quiet, and legally separate. 5 acres, a modest house, a detached workshop, and a long frontage strip along the stone entrance to a subdivision called Briar Glen Estates. Pretty signs, manicured shrubs, the usual suburban stage set. My property touched their edge, but it wasn't on their plat, not in their covenants, and not in their jurisdiction. I checked that before closing, just like I checked flood exclusions and fraud clauses line by line twice. The first red flag came before I even unpacked my boxes. A neighbor I'd never met pulled over, lowered his window, and said, "You didn't get this from me." He handed me a screenshot from the HOA board agenda. My address was listed under the line, Boundary Integration Opportunity. That phrase immediately told me 2 things. First, they discussed my land before ever speaking to me. Second, they weren't confused. This was planned. I went inside, opened my closing binder, pulled the deed exception, and cross-checked the parcel number with the county GIS map. I saved the screenshot, printed the map, and started a folder on my desk labeled Timeline in bold letters. The next afternoon, Karen introduced herself. She stepped out of a white SUV, pressed slacks, and a cream blouse, carrying a leather folder like she was walking into mediation, expecting to win. Her smile was that dry, managerial warmth people use when they want compliance before conversation. "Mr. Hale," she said, extending her hand. "I'm Karen Mercer, president of Briar Glen Estates. I wanted to personally welcome you to the area." I didn't shake her hand. "Appreciate the thought," I said. Her smile tightened a fraction. "Your parcel sits at a very sensitive entry corridor for our community. We maintain a certain standard here. Roads, lighting, drainage, monument frontage. Everyone benefits, so everyone contributes." There it was, not a welcome, but a billing statement in heels. She handed me a packet titled Voluntary Road Maintenance and Architectural Harmony Agreement. I stood there, reading just enough to see the trick. One paragraph said voluntary, but 2 paragraphs later, it said all impacted parcels are required to participate in shared maintenance obligations. I looked up at her. "You use the word voluntary and mandatory on the same page," I said. "It's just administrative phrasing," she said, still smiling. "Once you understand the benefits, I'm sure you'll sign." I calmly told her that my tract was excluded, recorded, and not subject to HOA governance. She gave a small laugh, like I had made a charming mistake. "Well," she said, tucking a strand of hair behind her ear, "that's not how the board sees it. That line mattered." I wrote it down the second she left. Then I gathered my first hard piece of evidence. I drove to the public road shoulder, where I was legally allowed to photograph her property. Her lot had a brand new pergola pushed right into a setback line, something her own handbook prohibited. No posted approval notice. No county permit. I pulled up the permit portal on my phone, searched her address, and found nothing. If Karen wanted to preach compliance while skating on her own rules, I wanted that hypocrisy documented from start. I answered her packet the way people like Karen hate most, by certified mail. My letter was 1 page, polite but cold. Attached were copies of the deed exception, county plat, and a direct refusal to sign any maintenance agreement or submit to any HOA review process. When the green return card came back, signed by their office manager, I stapled it to my letter, wrote the date on top, and slid it into my timeline folder. 3 days later, they escalated. I got an email from the management company informing me that my address had been placed in temporary enforcement status pending board review. According to them, any visible changes to the frontage, driveway edge, utilities, or exterior design now required HOA coordination. That was fake authority dressed up as process. But the real mistake was attached at the bottom. They had sent me a PDF board packet that they should have flattened first. When I opened the file properties, the internal revision history still showed the working title. Convert excluded parcel_phase 2. That wasn't an accident. That was intent with sloppy metadata. I saved the file, captured screenshots of the properties page, then called the county recorder. By late afternoon, the recorder emailed me back confirming that no amendment, annexation, covenant supplement, or recorded easement had ever been filed to pull my tract into Briar Glen. I printed the email. Evidence goes stale if you leave it on a screen. Friday morning was when Karen stopped pretending. I was out front with coffee when a utility truck rolled up, followed by an irrigation company van and a pickup loaded with pavers, conduit, and trenching tools. Karen stepped out behind them in sunglasses and white slacks, moving like she was hosting a ribbon cutting. Two laborers started spraying paint marks along my frontage strip near the stone entry wall. Another man uncoiled low-voltage cable. I set my mug on the porch rail and walked down to the survey pin. "Morning," Karen called, cheerful as a knife. "We're installing safety lighting and drainage improvements at the entrance. Shared infrastructure long overdue." One of the laborers drove a spade into my side of the marked line. I raised my hand, "Stop right there." Karen didn't even look at the worker. She kept her eyes on me. "This will move much faster if you don't make it adversarial." That sentence told me the goal and the mechanism. The goal was to create physical facts on my land. The mechanism was simple: get the work in first, then force me to live with it until fighting it became more expensive than signing. I stepped back onto my property, took out my phone, and started recording. I filmed the workers, Karen supervising, the truck logos, the spray marks crossing my survey stake, and the permit portal on my screen showing no permit for the address. Then I asked the foreman loud and clear, "Have you seen a recorded easement?" He looked at Karen first. That was answer enough. Then he said, "Ma'am told us this was already cleared through the community." "Community isn't a county office," I said. Karen turned to the workers. "Continue." That was her mistake. She didn't touch a shovel. She didn't have to. Her order was enough. I told the workers they were standing on excluded private property, that I was recording, and that any entry beyond the stake would be trespassing at the direction of the HOA president. Karen took out her phone and called 911. Her voice immediately changed, higher, faster, wounded. "Yes, I need a deputy. We have an obstructed property owner interfering with authorized utility work at the Briar Glen entrance. He's escalating and refusing lawful access." No panic, no screaming, just that clean, calculated performance meant to turn private coercion into official pressure. I kept recording. When the deputy arrived, Karen was already mid-speech, explaining shared corridors, emergency lighting, and community rights. I didn't interrupt. I let her build a rope first. Then I handed the deputy my deed copy, the plat, and the recorder's email. I showed him the flag line and asked the foreman again on camera if he had any recorded easement in hand. He said no. The deputy asked dispatch to note the incident, then wrote the number on his card and handed it to me. "Keep your workers off the marked line until this is verified," he told the foreman. Karen's jaw tightened. "Officer, with respect, this is delaying approved community work." He looked at her and said, "Approved by who?" She didn't like that question because it was the only one that mattered. The moment the deputy pulled away, I started my response. I called a licensed surveyor and had him res-take the frontage before sundown. I called my attorney and had her send preservation letters to the HOA management company, irrigation contractor, and lighting subcontractor. Before dinner, she filed for emergency injunctive relief with the incident number, the plat, the survey photos, and still frames from my video. The next morning, the line was impossible to miss. Bright survey flags, fresh stakes, paint marks corrected by a man with a license, and no patience for suburban fiction. Then I opened the second front. A title officer I knew from my catastrophe days searched the recorder backlog and found a rejected filing from 6 months earlier. A generic maintenance memorandum the HOA had tried to record against several non-member parcels, including mine. It had been rejected for lack of legal basis. That mattered because it proved Karen already knew she had no claim. Then the irrigation estimator called me privately. His voice had that tone contractors get when they realize a job can cost them more in court than it pays on paper. He forwarded me the unsigned scope sheet and internal notes. One line was highlighted in yellow. President authorization, non-member strip, complete before objection. That wasn't beautification. That was a rush job designed to manufacture leverage. Karen answered the injunction by reaching for more paper. A lien warning, a cease and desist. A board notice saying I would be liable for delay costs if I interfered with community infrastructure. They attached a color map shading my frontage as if it were already under HOA control. The legend referenced a revised plat book that didn't exist. So, I preserved everything. Envelopes, postmarks, certified labels, email headers, the fake map, the unsigned scope sheet, the recorder rejection, the file metadata. Every time they tried to shove me, they left fingerprints. By Monday, Karen decided to make it public. She set up a special compliance session near the stone entrance with 2 board members, the contractor foreman, the management rep, and an off-duty deputy working private security. Folding chairs, bottled water, the whole fake official pageant. A few neighbors lingered nearby, pretending not to watch. Karen stood beside a spool of cable and smiled at me like she had already won. "Mr. Hale, this could have been cooperative," she said. I held my folder against my side. "You're confusing confidence with jurisdiction." She gave a small laugh for the audience. "The county supports established infrastructure." That line aged badly in under 10 minutes because then the county engineer arrived. Not alone. With him came the on-duty deputy, my surveyor. The management rep suddenly looked pale, and the contractor foreman carried a packet he clearly decided he didn't want to die with. Karen brightened when she saw the county truck. She thought the room had tilted toward her. The engineer stepped onto the frontage, opened the plat, and said, "Before anyone puts steel in the ground, we're going to be very clear about where this line is." Karen started talking over him. "Exactly. Thank you. We've been trying to explain that." He held up a hand. "No, ma'am. You're going to listen now.